You wake up. It is Tuesday. You make coffee. You glance at your phone. You leave the house a few minutes late. So you cut across your neighbor's yard the short way, the way you always go. At the corner, you cross the street before the light changes because there are no cars coming, and standing there waiting feels pointless. At work, someone asks you to cover for them, and you tell your manager they stepped out for a moment when actually you have no idea where they are. Later, your co-worker lends you a socket wrench to fix something in your car, and you still have it sitting in your garage 2 weeks later because you keep forgetting to bring it back. That is your Tuesday. Here is what would happen to you under the law of the Assyrian Empire. Cutting across your neighbor's cultivated land without permission, that is trespass on protected property. The penalty is a flogging, not a symbolic one. The records specify 50 strokes, administered publicly, followed by a period of compelled labor. The crossing of the street against the signal is trivially small by comparison, but within a legal system that treated the smallest violation of public order as an affront to the divine will of the king, even minor transgressions could be escalated at the discretion of any judge who decided the example needed to be made. The lie you told your manager that one is interesting. In Assyrian law, bearing false witness in any matter that touched commerce, property, or civic obligation carried a penalty of mutilation to the mouth. The exact form varied depending on the period and the specific tablet, but the logic was always the same. The part of you that committed the crime would answer for it. The socket wrench sitting in your garage, if it happened to belong to a temple storehouse, or if the owner chose to press the claim as theft rather than borrowing, which was entirely within their legal right, you could be put to death, not fined, not jailed, executed, and you have not gotten out of bed yet on Wednesday. Now hold that feeling for a moment, because that is the point of this. These were not the laws of some isolated, forgotten tribe living at the edge of the known world. The Assyrian Empire, at its height, was the largest political structure human civilization had ever produced. Its capital at Nineveh, in what is now northern Iraq, held somewhere between 100,000 and 150,000 people, numbers that would not be matched by any Western European city for another 2,000 years. Its armies marched from the Persian Gulf to the borders of Egypt. Its administrative system, its writing, its art, its literature, all of it was the standard against which the ancient world measured sophistication, and its law had no ceiling. That is the phrase that stays with you once you spend any time with the Middle Assyrian Laws, which are the specific body of legal text this documentary is built around. They were inscribed on clay tablets around 1176 years before the birth of Christ, give or take a generation, in the city of Ashur, which sat on the western bank of the Tigris River. They were discovered by German archaeologist Walter André and his team during excavations between 1903 and 1914. They were written in a cuneiform script that took decades to fully decode and translate, and when scholars finally read them in full, the picture they revealed was something that the history books have been quietly uncomfortable with ever since. Most people who have heard of ancient Mesopotamian law think of Hammurabi, the great stela, the bas-relief of the king standing before the sun god Shamash, receiving the laws like a gift from heaven. 282 provisions, organized, numbered, framed with a prologue about how the king was appointed to make justice shine in the land like the sun. It is the oldest substantial legal code most people can name, and it sits in a glass case at the Louvre in Paris, and it has a replica in the lobby of the United Nations in New York. The Middle Assyrian Laws have no replica in any lobby. They survive across 14 groups of tablets, labeled simply A through O, by modern scholars, and of those several are either severely fragmented or lost entirely. What remains covers approximately 115 individual laws. And here is the number that matters. More than 60% of the surviving provisions specify death, mutilation, or flogging as the penalty. By comparison, Hammurabi's famous code, the one we hold up as the dawn of civilized jurisprudence, prescribes death in roughly 30 of its 282 laws. The Assyrian code does not prescribe death as the exception. It prescribes it as one of several available options on an open-ended menu, and it explicitly grants judges the authority to increase any penalty beyond what is written, if they feel the situation warrants it. That phrase appears in multiple tablets, in varying forms, but the meaning is always the same. There is no upper limit. The judge may increase the punishment as many times as he pleases. Let that settle. Before we go further, if this kind of history is what you come here for, the buried stories, the ancient laws, the questions that scholars have been quietly arguing about for a century, and that most documentaries skip right past, then this channel is exactly where you want to be. Every video here follows the same approach. The real evidence, the real researchers, the real unresolved questions. If you have not subscribed yet, now is a quiet moment to do that, and turning on the notification bell means you will know when the next piece of this arrives. It genuinely helps, and it means this kind of work can keep being made. Now back to Assyria, because we have only just opened the door, and what is waiting inside those tablets is unlike almost anything else that has survived from the ancient world. The laws we are going to walk through are not myths. They are not the dramatic invention of a later civilization trying to make its enemies look barbaric. They are administrative documents, legal texts, written by scribes, stored in archives, buried beneath the floors of a building that archaeologists still cannot fully identify, and undisturbed for nearly 3,000 years, until the early 20th century brought them back into the light. They cover women, they cover slaves, they cover debt, property, bodies, and the specific mechanics of how a person could be destroyed by the state, while the state remained, in its own framing, entirely just. And the more carefully you read them, the more a single question rises to the surface. Slowly, the way questions do when the answer has been sitting beneath centuries of silence. Not whether these laws were brutal, but whether the people who lived under them ever had a word for what that felt like. The Tigris River runs fast and cold in the north. Not the slow, silted southern stretch that most people picture when they think of ancient Mesopotamia. The flat delta country, the marshes, the wide brown water moving lazily toward the Persian Gulf. Up in the north, where the mountains of Anatolia begin to descend toward the plains of what is now Iraq, the Tigris cuts through harder country. The banks rise steep, the current has teeth, and it was on a promontory above that river, at a site the ancient world knew simply as Ashur, that one of the most consequential civilizations in human history quietly assembled itself across a period of roughly 1,500 years. Most people understand Mesopotamia as a single-story Sumer, then Babylon, maybe a mention of Akkad, a neat progression that eventually leads to Greece and Rome and the world we recognize. Assyria does not fit that narrative cleanly, which is part of why it tends to get compressed into a single sentence in survey courses. But to understand why the laws we are examining existed, and why they were written the way they were, you need to understand the world that produced them. Because the Middle Assyrian laws did not arrive from nowhere, they were the legal expression of a specific civilization at a specific moment of transformation, and that transformation had been building for centuries. The history of Assyria divides, broadly, into three periods. The first is what scholars call the Old Assyrian period, running from roughly 2000 to 1750 years before the birth of Christ. This was not yet an empire. It was a city-state, centered on Ashur, built on trade. The merchants of Ashur were among the most sophisticated commercial operators the ancient world had yet produced. They established a network of trading colonies. The Assyrian word for them was karum, meaning harbor or port, though most of these were inland, stretching hundreds of miles from the Tigris heartland into the heart of Anatolia. The most extensively excavated of these colonies is Kultepe, in what is now central Turkey, where archaeologists working continuously since 1948, under the Turkish Historical Society, and later Ankara University, have recovered more than 23,000 cuneiform tablets. Most of them are business records, contracts, loans, dispute resolutions, letters between merchants and their families back home. They are the paperwork of a civilization that understood, very early, that trade required law, and that law required writing. That early commercial legal culture is important background. The Assyrians did not begin as conquerors, they began as accountants. The second period, the Middle Assyrian Empire, running from roughly 1363 to 1056 years before the birth of Christ, is where the tablets at the center of this documentary belong. This is the period when Ashur transformed from a wealthy trading city into the administrative capital of a genuine territorial empire. The kings of this period, Ashurubballit I, Adad-nirari I, Tukulti-Ninurta I expanded Assyrian control aggressively northward into the Armenian highlands, westward toward the Euphrates, and southward into Babylonian territory. Tukulti-Ninurta I, who ruled from roughly 1243 to 1207 years before the birth of Christ, went further than any of his predecessors. He sacked Babylon itself. He carried the sacred cult statue of the Babylonian god Marduk back to Ashur as a trophy. He composed an epic poem about his own victories, one of the earliest known examples of royal literary self-promotion. It is during this period, this moment of maximum military expansion and political self-confidence, that the Middle Assyrian laws were compiled and inscribed. That timing is not coincidental. Empires need uniform law. When your territory expands to cover dozens of different ethnic groups, languages, and local customs, you need a single framework that tells everyone conquered and conqueror alike what the rules are. The Middle Assyrian laws were, among other things, an administrative instrument of imperial consolidation. The third period, the Neo-Assyrian Empire, from 911 to 609 years before the birth of Christ, is the one that tends to dominate the historical imagination. Ashurnasirpal II, Shalmaneser III, Tiglath-Pileser III, Sargon II, Sennacherib, who destroyed Babylon so completely that ancient sources describe the rubble being swept into the Euphrates. These are the names attached to the palace reliefs in the British Museum, the massive human-headed winged bull statues called Lamassu, the annals recording campaigns of systematic destruction in language so precise and so calm that it reads almost like a weather report. The Neo-Assyrian kings did not operate under the Middle Assyrian laws in a strict sense. By that point, the code was centuries old, and the legal landscape had evolved through royal decrees, administrative practice. But the underlying logic, the foundational assumptions about punishment, about the body as a site of legal consequence, about the king as the living embodiment of divine justice, all of that persisted. And then there is the concept that sits at the center of everything the Assyrian state believed about itself. The city of Ashur was not merely the capital. Ashur was also the name of the chief god. The king did not rule on behalf of the god. The king ruled as the god's deputy, his designated hand on earth, his enforcer. There was no separation between religious authority and legal authority, because they were, in Assyrian political theology, identical. The law was divine will made legible on clay. To break the law was not merely a civic offense. It was an act of cosmic disorder, a disruption of the order that held the universe together. That is the framework within which those 115 surviving provisions were written. That is the world that made those laws, and it is a world where the distance between an ordinary Tuesday and the complete destruction of your life was, legally speaking, almost nothing at all. Tablet A is where most scholars start, and most scholars also admit it is where the reading becomes difficult. Not difficult in the linguistic sense, the cuneiform has been decoded, the Assyrian translated, the provisions numbered and cross-referenced across multiple scholarly editions going back to the 1930s. The difficulty is of a different kind. It is the difficulty of sitting with what the text actually says and holding it alongside the fact that this was the law. Not a threat, not an atrocity committed in the chaos of war. Written down, stored, administered by officials, applied to real human beings who had names and families and debts and fears, and who had no mechanism whatsoever for appealing any of it. Tablet A of the Middle Assyrian Laws is almost entirely concerned with women. Out of the 59 provisions that survive on that tablet, the overwhelming majority govern what women can wear, where they can go, who they can speak to, what happens to their bodies when someone else commits a crime, and what happens to their bodies when they are accused of committing one themselves. The scope is total. The logic is consistent. And once you understand the framework underneath it, the individual provisions stop being a list of horrors and become something more unsettling, a coherent system. Start with the veil. Modern readers tend to interpret veiling as a religious practice, a marker of modesty or faith. In the Middle Assyrian legal world, the veil was none of those things. It was a legal status marker, a form of identification. The law specified, with considerable precision, exactly which women were required to veil in public and which women were forbidden from doing so. Married women veiled, widows veiled, Daughters of free men who accompanied their mothers in public veiled. Prostitutes did not veil. Slave women did not veil. The prohibition was not a matter of custom or social expectation. It was enforceable law, and the penalty for crossing it ran in both directions with equal severity. A free married woman who went out unveiled could be stopped and questioned. A prostitute who was caught veiling in public faced 50 strokes of a rod, administered publicly, followed by having pitch poured over her head. The pitch provision is not a metaphor. It appears in the text directly. Hot pitch, poured deliberately, on a living person as a legally sanctioned punishment for wearing the wrong piece of cloth. What this system created, in practical terms, was a street-level surveillance apparatus in which every woman's legal and social status was visible at a glance and enforceable by any passerby who chose to report a violation. The veil was not protecting women. The veil was categorizing them for the convenience of the men around them. Archaeologists have noted that this makes the Assyrian veil provisions one of the earliest documented examples in recorded history of the state, using dress as a legal instrument of class enforcement, not merely social convention, but written law with physical penalties attached. Now move to the adultery provisions, because this is where the internal logic of the system becomes fully visible. Middle Assyrian Law, Tablet A, Provision 12. A man who catches his wife with another man may kill them both, on the spot, in the moment of discovery. He may mutilate them however he chooses. He may cut off their noses. He may blind them. He may do both. He may do neither, and choose instead to bring formal charges, in which case the same range of punishments would be administered by the state. What he may not do is punish only one of them and spare the other. The law is explicit on this point. Whatever fate the husband chooses, it must fall on both parties equally. That last clause is sometimes cited as evidence of a kind of primitive fairness. Both the wife and the man she was with receive identical treatment. But read it more carefully. The husband decides the punishment. The husband administers it, or initiates it. The husband faces no legal consequence regardless of what he does to either of them. The equality in this provision exists entirely within a frame where one person holds total power and two people hold none. Provision 8 covers a different kind of physical harm, and it is one of the provisions that tends to stop readers cold. If a woman strikes a man's testicle during a dispute, meaning a physical altercation, not a sexual context, the law specifies that one of her fingers is to be cut off. If in striking him she crushes one testicle, both of her eyes are to be gouged out. If both testicles are injured and both are crushed, she is to be killed. The scaling here is important to sit with. A finger for a strike, both eyes for one crushed testicle, death for two. The progression is not arbitrary. It follows the same mirror logic that runs through much of the code, matching the severity of punishment to the severity of injury. But notice what is absent. There is no parallel provision covering what happens to a man who strikes a woman and injures her in a comparably serious way. That provision does not exist in the surviving tablets. Whether it existed in the missing ones is one of the questions that cannot currently be answered. The rape provisions in Tablet A are among the most complex and, in their own way, the most revealing of the entire code. Provision 23 covers the rape of a married woman by a man who is not her husband. The rapist is to be flogged 50 strokes and 1 month of compelled labor follows. But the central penalty is something else entirely. The rapist's wife is to be handed over to the husband of the woman who was assaulted, to be used however that husband chooses. Read that again slowly. The man who committed the assault is flogged, but his wife, who committed no act of any kind, is handed to another man as a form of compensation. She becomes the instrument of restitution for a crime she had no part in. Her body is the currency in which the debt is paid. This is the vicarious punishment principle operating at its most explicit, and it will come up again in different forms throughout the code. Provision 55 addresses the rape of an unmarried girl. Here, the rapist's punishment includes a financial payment to the girl's father, and the requirement that the rapist take the girl as a wife if the father chooses. If the girl had a previous betrothal, the financial penalty increases. The girl herself has no recorded voice in any part of this provision. Her status shifts from daughter to wife without any documented moment in which her preference is considered a relevant legal fact. Martha Roth, whose 1995 translation through the Society of Biblical Literature remains the standard, scholarly English edition of these tablets, notes in her analysis that the Assyrian provisions concerning women represent a level of systematic legal control over female bodies that goes beyond any comparable ancient Near Eastern code. The word she uses in her academic framing is comprehensive. In a research context, that word carries significant weight. What makes all of this historically significant, beyond its obvious horror, is the question it raises about daily life. These laws were not theoretical, they were inscribed, stored, and administered in a functioning imperial bureaucracy. Judges applied them. Men living under this system understood, with legal clarity, exactly how much power the law placed in their hands over the women around them. And the women living under this system understood it too. That understanding the slow, daily weight of a legal order that had written your body into its provisions as object rather than subject left almost no trace in the historical record. The tablets survived. The silence of the people who lived under them is nearly total. Nearly, because here and there, buried beneath centuries of undisturbed sediment at sites like Nuzi and Nippur and the trading colonies of Anatolia, archaeologists have found the whispered edges of individual lives. A woman contesting a debt claim, a widow defending her property, a daughter whose name appears once in a transaction record and never again. They were there. The law simply was not written for them, and somehow, across nearly 3,000 years of silence, that fact still lands with a weight that is difficult to explain, the way certain historical truths do not stay in the past where you put them, but follow you quietly into whatever room you're sitting in right now. Speaking of which, wherever you are listening to this, whatever hour it is where you are, I am genuinely curious. Drop it in the comments. The city, the country, the time on your clock. There is something about this particular subject, laws written to govern the most ordinary moments of ordinary lives, that feels different depending on whether you are hearing it at 2 p.m. with sunlight coming through a window, or at some quiet hour past midnight when the rest of the house has gone still. Either way, you found this, and the fact that people from so many different places and different hours keep finding their way to these buried stories is the reason this channel exists. Now back to Assyria, because the laws governing women were only one corner of a much larger system, and the next corner is, if anything, harder to look at directly. There is a concept in modern legal philosophy called individual culpability. It is so fundamental to how contemporary law operates that most people have never had to think about it as a concept at all. It simply feels like common sense. You are responsible for what you do. You are not responsible for what someone else does. The law reaches you through your own actions, your own choices, your own hands. Someone in your family commits a crime, and you go home and make dinner. That assumption did not exist in Assyrian law. What existed instead was something scholars call vicarious punishment, the legal principle that a crime committed by one person could be paid for, in whole or in part, by someone who had no involvement in that crime whatsoever. A wife, a household slave, the people closest to you were not merely your family under Assyrian law. They were your legal collateral. They were the currency in which your debts to the state and to your neighbors could be settled, whether or not they had any knowledge of what you had done. This was not a loophole. It was not an abuse of the system by corrupt officials operating outside the written code. It was inscribed on clay, stored in administrative archives, and applied by judges who understood themselves to be administering divine justice on behalf of the king and the god Ashur simultaneously. Tablet A, Provision 55, which appeared in the previous section in the context of rape, is worth returning to here for a different reason. The man convicted of raping an unmarried girl does not simply pay a fine or receive a flogging. His wife is handed over to the girl's father. She had no part in the assault. She may not have known the victim. She may not even have known her husband had committed the act. None of that is legally relevant. Her body is the compensation. Her life is the payment. The law does not ask her anything. Tablet A, Provision 9, covers a man who kisses another man's wife without her consent in a public space. The penalty for the man who committed the act is 50 strokes of a rod and a month of labor. But the provision does not stop there. If the husband of the woman who was kissed chooses to press the matter further and the law explicitly gives him this choice, then the offending man's wife may be brought forward to receive an equivalent punishment. The woman who was kissed is the victim. The woman who is then flogged is the offending man's wife, who was somewhere else entirely when the incident occurred, living her own life, entirely uninvolved. 50 strokes. For being married to the wrong person, Tablet B, Provision 2, moves the vicarious punishment principle into the territory of commercial debt, and this is where it becomes most visible as a structural feature of Assyrian economic life, rather than merely a feature of criminal law. When a man defaults on a debt, meaning he cannot repay what he borrowed, which in a society with annual interest rates of between 25 and 33% on silver loans, was not a rare or exceptional circumstance. The creditor has specific legal rights over the debtor's household. He may take the debtor's wife, he may take the debtor's children, he may take household slaves, he may put them to work in his service for the duration of the debt. The provision includes one qualification that is sometimes cited as evidence of a limiting principle. The creditor may work them hard, but he may not deliberately kill them. That is the boundary. The boundary is not that he cannot beat them, cannot overwork them, cannot subject them to conditions that a person of reasonable health could not survive indefinitely. The boundary is that the death must not be deliberate. In practical terms, for a farming family hit by one bad harvest in a region where droughts were a documented and recurring reality, this provision described a trap with no realistic exit. The debt grows at 25% annually. The family members working in the creditor's household do not earn wages that offset the principal. The original debtor, now without his household labor, cannot farm efficiently enough to generate the surplus needed to repay. It compounds. Archaeologists have noted that private archive texts recovered from Nuzi, a site in what is now northeastern Iraq, excavated between 1925 and 1931 by a team that included scholars from Harvard University under the direction of Edward Chiera, contain transaction tablets, recording entire family groups transferred as debt payment in a single document: father, mother, adult children, sometimes listed by name, sometimes listed simply by number. One tablet, analyzed by Maynard Maidman in his 2010 study of the Nuzi archive, records a transfer so complete that the household effectively ceased to exist as an independent unit after the transaction was finalized. The names on those tablets are real names. They belong to real people who woke up one morning in a house they recognized and went to sleep that night in someone else's service, legally, permanently, through no act of their own. Tablet C and the related Tablet G address a different category of vicarious consequence: the laws governing escaped slaves and the people who encountered them. If a slave ran away and a free person encountered that slave and chose not to report them, the free person faced the removal of their nose and ears. If the same free person actively sheltered the slave, gave them food, a place to sleep, assistance of any kind, the punishment extended further, and the compensation paid to the slave's original master included the right to take one of the sheltering person's own slaves as replacement property. So, the person who showed a runaway human being a moment of basic decency lost their nose, their ears, and a member of their own household. What remains unexplained, and what several contemporary Assyriologists, including Eckhart Fromm of Yale University, have noted in recent scholarship, is why the vicarious punishment principle intensified so markedly in the Middle Assyrian period compared to earlier Mesopotamian legal codes. Hammurabi's provisions, for all their severity in other respects, do not apply collective consequence to innocent family members with anything like the same systematic consistency. One theory suggests the intensification reflects the pressures of empire, a rapidly expanding territorial state that needed mechanisms of social control capable of operating across diverse populations without a large permanent judicial infrastructure in every province. If the consequences of a man's crime could fall on everyone around him, then everyone around him had a personal interest in ensuring he did not commit one. The family as surveillance unit. The household as the state's enforcement mechanism turned inward on itself. It is an efficient system, in a cold and specific sense of that word. It is also a system in which the concept of innocence as a legal protection simply did not function. Your innocence was not a shield, It was irrelevant. What mattered was your proximity to someone who had broken the law, and the degree to which your body or your labor represented a resource the state or an aggrieved party could reasonably claim. You did not have to do anything wrong. You simply had to be there. Every legal system draws a line somewhere. It may be drawn imperfectly. It may be drawn in a place that looks, from a later vantage point, like a moral failure. But the line exists some point at which the punishment stops, some ceiling above which the state acknowledges it cannot go, some written or unwritten agreement that the law, however severe, has a boundary. Assyrian law did not draw that line, or more precisely, it drew the line and then handed a single man the legal authority to move it whenever he chose. The phrase appears across multiple tablets in varying forms, but the meaning is consistent and unmistakable. After specifying a penalty flogging, mutilation, a period of labor, a fine, the text adds a qualifying clause. The judge may increase the punishment. In some provisions, the language is even more explicit. The king may do with him as many times as he pleases. The written penalty is not the sentence. It is the floor. What happens above that floor is entirely at the discretion of whoever holds authority in that particular moment, in that particular courtroom, in that particular province of an empire that stretched from the mountains of what is now Turkey to the edge of what is now Egypt. To understand what that clause meant in practice, you need to understand the structure of Assyrian judicial authority, because it was not a unified system in the way modern legal systems attempt to be. There were multiple overlapping tracts of legal jurisdiction operating simultaneously. Local elders and city assemblies handled certain categories of dispute, property lines, inheritance claims, commercial contracts. Temple priests had independent jurisdiction over crimes committed against temple property or within temple precincts, which in a civilization where the major temples also functioned as banks, granaries, and administrative centers meant their reach was considerable. And above all of it sat the king, whose authority was not merely supreme but theologically absolute. He was the deputy of the god Ashur, and his judgment was, by definition, divine will made legible on earth. The infinite punishment clause existed at every level of this structure, but it was at the royal level where its consequences became most visible in the historical record. The Neo-Assyrian royal annals, the official inscribed accounts of the king's military campaigns and administrative achievements, are among the most extensively studied documents from the ancient world. They are also among the most methodically violent texts that human civilization has produced. Ashurnasirpal II, who ruled from 883 to 859 years before the birth of Christ, left behind annals that describe the treatment of conquered peoples in language so specific and so calm that the calmness itself becomes a kind of evidence. He describes administrative outcomes. He built a tower of heads outside a rebellious city. He flayed the leaders of a revolt and draped their skins over the walls. He burned captives alive, impaled survivors on stakes along the road, and cut off the hands and feet of men who had resisted his army. All of this is recorded in the first person, in the past tense, as a list of accomplished facts. These annals are held at the British Museum under catalogue number BM 118805, and they were translated and analysed in detail by A. Kirk Grayson of the University of Toronto in his 1991 volume of the Royal Inscriptions of Mesopotamia series. Grayson's analysis makes a distinction that is important for how we read these texts. He notes that the annals are not straightforward historical records. They are ideological documents, composed by royal scribes for the purpose of projecting power to foreign states, to potential rebels. The question of how much of what they describe was literally carried out and how much was rhetorical amplification is one that Assyriologists have debated for decades. But here is the complication. The Nimrud letters change the picture. Discovered in 1952 during excavations at the ancient city of Kalhu, known today as Nimrud, in northern Iraq, and published in a series of articles beginning in 1955 by H.W.F. Sags in the journal Iraq, the Nimrud letters are something the annals are not. They are internal administrative correspondence, letters between provincial governors and the royal court, between military commanders and their superiors, between local officials dealing with specific problems and the central bureaucracy that expected results. They were not written for posterity, they were written to get things done. And in their mundane, practical, bureaucratic language, They describe executions and mutilations and collective punishments with the same emotional register that a modern official might use to describe a road repair. A governor reports that the men responsible for a grain shortage have been dealt with. A military commander notes that the inhabitants of a village that harbored fugitives have been processed according to the relevant provisions. The violence is not celebrated in these letters. It is not theatrical. It is just work. The ordinary administrative output of a state apparatus that had fully internalized the infinite punishment clause as an operating principle rather than an exceptional measure. What remains unexplained is the gap between the number of capital sentences specified in the law tablets and the relatively sparse execution records that appear in the administrative texts from civilian contexts. One theory suggests that the written penalties in the MAL functioned partly as deterrents, that the very existence of uncapped punishment suppressed the behavior it threatened to punish, meaning the law's most extreme provisions were invoked less frequently than their prominence in the tablets might suggest. Another theory, held by scholars including Karen Radner of Ludwig Maximilian University in Munich, suggests that the administrative record is simply incomplete, that the documentation of routine legal proceedings at the local level has not survived in the same density as royal correspondence, and the absence of evidence is not evidence of absence. Both theories can be true simultaneously. The threat was real because the capacity to carry it out was real. The Nimrud letters proved the willingness. The law tablets proved the authorization, and the authorization had no ceiling. There is one more dimension to the infinite punishment clause that tends to get less attention than the dramatic specifics of impalement and flaying, but which may be the most consequential feature of the entire system for the people who lived under it day to day. The clause did not only apply to capital crimes, it applied to everything. A man convicted of a property dispute who received the written penalty of a fine and a flogging could, at the discretion of the presiding judge, also have his ears removed. A woman whose assigned punishment under a specific provision was 50 strokes could find that number doubled or tripled on the judgment of whoever was administering the sentence that day. There was no due process mechanism to challenge an enhanced sentence. There was no written standard specifying what circumstances justified an increase. There was no appeals court waiting at the next level of the system to review whether the enhancement was proportionate. There was the judge. And above the king, there was the God silent, represented only by the men who claimed to speak for him, who had written the law, who had written into the law the clause that allowed them to exceed it. The ceiling was always exactly one man's mood above, wherever the written penalty stopped. And in a civilization of several million people, administered by officials whose judgment was legally unchallengeable and theologically sanctioned, that was not an edge case. That was the system. Here is something that does not fit the way most people think about ancient law. Murder in the Assyrian legal system was, in a significant number of cases, a civil matter, not a criminal one, not an offense against the state that the state felt compelled to pursue and punish on its own authority. A civil matter meaning a dispute between two parties, the family of the person who was killed and the person or family responsible for the killing, to be resolved through negotiation, compensation, and payment. The technical term in the ancient Near Eastern legal tradition is blood money, a sum paid by the killer or the killer's family to the victim's family in exchange for the formal relinquishing of the right to vengeance. It appears in Assyrian legal and administrative texts. It appears in Hammurabi's code before it. It appears in early Germanic law codes, in early Islamic jurisprudence, in the Hebrew Bible. It is one of the oldest documented mechanisms for managing lethal violence within a community. What this means, in practical terms, is that under certain circumstances, a man who killed another man could pay a sum of silver, satisfy the legal requirements of the case, and return to his life. A man who stole from the wrong place could not. Tablet B, Provision 9, of the Middle Assyrian Laws, is among the shortest and most absolute provisions in the entire surviving code. Theft from a royal storehouse, from the administrative infrastructure of the palace, the warehouses where grain and silver and oil and timber were collected, stored, and redistributed across the empire, carried a single penalty, with no alternatives listed, no mitigating circumstances acknowledged, no mechanism for compensation or substitution. Death, not flogging followed by repayment, not enslavement until the value was restored. Death, specified without qualification, in a legal text that in many other provisions goes to considerable lengths to enumerate options and conditions and graduated responses. Tablet A, Provision 11, addresses a different category of property crime, and it is the provision that most clearly reveals the mirror logic running beneath the entire Assyrian punishment architecture. A man who commits theft during a fire, who takes advantage of the chaos and destruction of a burning building to steal from the people whose property is being consumed, is to be thrown into that same fire. The method of the crime becomes the method of the punishment. You use the fire uses you. The law does not reach for a different instrument when the original instrument is available and appropriate. This principle, called talion in legal scholarship, from the Latin word for such, meaning the same, appears throughout ancient legal codes in the basic form most people recognize from the phrase eye for an eye. But the Assyrian application of it goes further than most comparable codes in one specific direction. It extends not just to bodily injury, where the mirror logic is at least intuitively comprehensible, but to the circumstances and methods of property crimes, which suggests a legal philosophy in which the manner of an offence carries moral weight equal to the offence itself. How you stole matters as much as that you stole. The fire provision also illuminates something about the social function of property law in Assyrian civilization that is easy to miss if you focus only on the individual penalties. A fire in an ancient city was not merely a personal tragedy for the people whose home or shop was burning, it was a community emergency. The grain stored in a neighborhood warehouse, the oil in a merchant's storeroom, the tools in a craftsman's workshop. These were not simply private possessions, they were nodes in a redistributive economic system that fed people through droughts, supplied armies on campaign, and maintained the administrative apparatus of an empire. It was, from the perspective of Assyrian legal thinking, an attack on the system that kept the civilization alive. That context reframes the severity of the penalty. Death by fire for stealing during a fire is still a death sentence for a property crime, but it is a death sentence imposed by a legal system that understood property not primarily as the expression of individual ownership, but as a component of collective survival infrastructure. The modern instinct to rank murder above theft on a scale of moral seriousness assumes a framework in which individual life is the supreme legal value. Assyrian law operated within a framework in which the integrity of the redistributive system was, in certain circumstances, weighted equally or above it. The temple added another layer of complexity entirely. Major Assyrian temples were not simply religious institutions in the sense that modern people use that word. They were simultaneously houses of worship, banks, granaries, legal archives, and administrative centers. The Temple of Ashur in the city of Ashur held not only the cult statue of the chief god, but also the land records, the commercial contracts, the debt tablets, and the stored surplus that a significant portion of the local population depended on. Stealing from the temple was therefore not merely an act of impiety. It was an act of economic sabotage against an institution whose collapse would have cascading consequences across the entire community. Temple priests in the Assyrian system had independent judicial jurisdiction over crimes committed against temple property. This created a two-track legal system operating in parallel: the royal track, administered by palace-appointed judges under the authority of the king, and the temple track, administered by priestly officials under the authority of the god. In cases of temple theft, a person could find themselves subject to proceedings in both tracks simultaneously, with no mechanism for consolidating the cases or limiting double jeopardy in the way modern legal systems attempt to do. One theory suggests this dual jurisdiction was not an oversight or a structural inefficiency, but a deliberate feature, a way of ensuring that crimes against the temple's economic resources were prosecuted with maximum vigor. Institutions that had direct personal interest in the outcome, independent of whatever political calculations might lead a royal judge to show leniency. What remains unexplained is why the surviving Mal tablets do not contain more extensive provisions, specifically governing temple theft, given how central the temples were to Assyrian economic life. Archaeologists have noted that the gap may reflect the existence of a separate body of temple law, internal priestly codes, governing temple conduct that was maintained independently and has not survived in recoverable form. The silver and grain that sat in those storehouses fed cities. The law that protected them had no flaw on what it would do to the person who reached inside, and the person whose hands had taken a life, in the wrong circumstances, might pay a sum of silver and walk home. The hierarchy was not arbitrary. It was a precise reflection of what the Assyrian state valued most and what it was most afraid of losing. Imagine you have been accused of witchcraft. You did not practice witchcraft. You do not know who made the accusation or precisely what they claim you did. You have no lawyer because the concept does not exist. You have no right to confront your accuser directly because the legal framework does not require it. You have no written standard of evidence that the prosecution must meet before the case proceeds to judgment. What you have is a river, the Euphrates, most likely, wide and cold in the early months of the year, running fast with snowmelt from the mountains to the north and west, or slower and warmer in the dry summer months, brown with suspended sediment, moving with a patience that has nothing to do with your situation. The river does not know you are innocent. The river does not know anything at all, but the law says the river knows everything, because the river is not simply water, it is the physical presence of Ea, the god of wisdom, and the deep, the deity who governs the boundary between the known world and the abyss beneath it. You are thrown in. If you survive, you are innocent. Ea has held you up, declared you clean, returned you to the living world. If you drown, you are guilty. The river has taken what belonged to the crime. This is the river ordeal, and it is one of the most ancient, documented judicial procedures in human history. Middle Assyrian Law, Tablet A. Provisions 17 and 22 both invoke the river ordeal in specific circumstances. Provision 17 covers the case of a woman accused of witchcraft by someone other than her husband, meaning an external accusation, a neighbor or community member making a formal claim. The accused woman is to be thrown into the river. Provision 22 addresses a different but related scenario involving a married woman accused of conduct that cannot be proven through witness testimony. Again, the river. The accusation of witchcraft in Assyrian law was not a minor charge. It was among the most serious categories of offense in the entire legal code, treated with a gravity that reflected deep institutional anxiety about the practice. Sorcery, the deliberate use of supernatural power to harm another person, was understood as an attack not merely on the individual victim, but on the divine order that held the world together. A witch was not merely a criminal. A witch was a destabilizing force in the cosmic structure, someone who had inverted their relationship with the divine hierarchy and was using that inverted power against the community. The river ordeal was specifically reserved for cases where human judgment was understood to be insufficient, where no witnesses existed, where the evidence was ambiguous, where the nature of the alleged offense placed it beyond the reach of ordinary legal reasoning. This is an important distinction. The Assyrian legal system was, in many respects, procedurally sophisticated. It understood the difference between testimony and accusation. It had mechanisms for evaluating contracts, verifying identities, and adjudicating property claims with considerable documentary precision. The river ordeal was not a substitute for that system. It was a supplement, a mechanism for resolving the cases that the human system explicitly could not. What this means in practice is that the ordeal was invoked precisely in the situations where guilt or innocence was most genuinely uncertain, which is also precisely the situation where the outcome of throwing a person into a river is most consequential. The cases that went to the river were the hard cases, the ambiguous cases, the cases where a different system might have said we do not have enough information to proceed, and therefore we will not destroy a person on insufficient grounds. The Assyrian system said instead we do not have enough human information, so we will ask the god. The practical mechanics of the ordeal are worth examining carefully because they suggest that the outcome was not entirely random, which raises its own uncomfortable questions. The Euphrates in flood season, roughly March through May, runs at a different speed and temperature than it does in late summer. A person thrown into the river during high water faces a current capable of pulling a strong adult swimmer under within minutes. The same person thrown into the same river in September faces a slower, shallower, more forgiving body of water. The season of the ordeal mattered enormously. So did the physical condition of the accused. A young man in good health, who grew up near the river and knew how to swim, faced a genuinely different trial than an elderly woman or a person weakened by illness, or someone who had never learned to swim because their life had given them no reason to. And the accusers knew this. One theory suggests that the timing of witchcraft accusations, and by extension the timing of river ordeals, was not random within Assyrian communities. That social knowledge of when the river was most lethal could be factored into the decision to bring a formal accusation. This cannot be proven from surviving texts, and it is important to be precise about that limitation. But it is a theory that has been raised by scholars studying the social function of the ordeal across ancient Near Eastern legal systems, and the structural logic it describes is difficult to dismiss entirely. Archaeologists have noted something else that complicates the simple narrative of the ordeal as divine arbitration. Cuneiform tablets recovered from Nippur, an ancient city in what is now south-central Iraq, whose archives span several centuries of Mesopotamian legal practice, record river ordeal verdicts as late as 550 years before the birth of Christ. That is more than 500 years after the Middle Assyrian Laws were inscribed. The Neo-Babylonian period. A completely different empire, a different dynasty, a different political world. Sophie Lafont, in her 1999 study of women, law, and justice in the Ancient Orient, published by the University of Freiburg, analyzed these late Nippur tablets and found that the ordeal continued to be applied with particular frequency in cases involving women accused of sexual or supernatural offenses, the same categories that dominated its use in the earlier Assyrian Code. The river outlasted the empire that codified it. What remains unexplained is the inner experience of the people who stood at the riverbank waiting. The tablets record verdicts. They record the legal consequences that followed survival or drowning. They do not record what a person thought or felt in the moment between the accusation and the water. That silence is 3,000 years old and shows no signs of breaking. But the river is still there. The Euphrates still runs through Iraq, still fed by the same northern mountains, still carrying the same brown sediment toward the same gulf. It no longer judges anyone, or at least, no written law currently requires it to. In the spring of 1903, a German archaeologist named Walter André arrived at a low, unremarkable mound rising from the flat plains of what is now northern Iraq, on the west bank of the Tigris River, roughly 200 miles north of Baghdad. The mound was called Kholat Shakat by the local population. André and his team from the Deutsche Orient Gesellschaft, the German Oriental Society, had come to excavate it. They suspected, based on earlier surveys and textual references in previously translated cuneiform documents, that beneath the surface of that mound lay the ancient city of Ashur, the capital, the place where the god and the city shared a single name, and where the legal and theological foundations of the Assyrian Empire had been laid down across more than 1,000 years of continuous habitation. They were right. Over the course of excavations that ran from 1903 to 1914, André's team uncovered temples, palaces, city walls, cemeteries, and administrative buildings of extraordinary historical significance. They recovered thousands of artifacts, hundreds of inscriptions, and a collection of clay tablets that would take decades to fully translate and publish. The excavation reports, published by André himself in a series of volumes through the Deutsche Orient Gesellschaft, remain foundational documents in the study of Assyrian archaeology. Among the finds recovered from a specific location within the site that André's team designated simply as Building G in their field records were the clay tablets that would eventually be identified as the Middle Assyrian Laws. And the first question those tablets raised before anyone had fully translated them, before the provisions about women and debt and vicarious punishment had been decoded and published, was not what they said. It was why they were there. Building G presented an interpretive problem that the excavation reports acknowledged but could not resolve. The tablets had not been found in open shelving of the kind used for active administrative archives, the organized, accessible storage that Assyrian scribal practice typically employed for documents in regular use. They had been found in a sealed context, beneath the floor, in a configuration that suggested deliberate concealment rather than routine filing. This is not, on its own, an unusual discovery in ancient Near Eastern archaeology. Buried deposits of tablets occur at multiple sites across Mesopotamia for a variety of reasons. Foundations, deposits, objects placed beneath buildings as ritual offerings at the time of construction are well documented. Emergency concealment during periods of military threat is equally well attested. Scribal schools sometimes buried, damaged, or obsolete tablets as a form of ritual disposal, treating inscribed clay with a degree of reverence that prevented simple discarding. The difficulty with Building G is that none of these standard explanations fits the specific evidence without remainder. The tablets were not foundation deposits. They show no signs of the ritual context that typically accompanies deliberate foundation burial, no accompanying objects, no configuration suggesting ceremonial placement. Emergency concealment during the city's violent destruction by the Medes and Babylonians in 614 years before the birth of Christ is the most commonly cited explanation, and it is plausible on its face. Ashur fell violently. The archaeological evidence of that destruction is visible across the site: burning, collapsed structures, the kind of sudden catastrophic end that would give anyone with valuable documents a compelling reason to hide them quickly. But here is where the explanation begins to complicate itself. The Middle Assyrian Laws were inscribed around 1176 years before the birth of Christ, during the reign of Tiglath-Pileser I. The city fell in 614 years before the birth of Christ. That is a gap of roughly 560 years. By the time someone buried those tablets beneath the floor of Building G, the laws they contained were not current legal documents. They were historical artifacts. The Neo-Assyrian legal landscape had evolved considerably through 5.5 centuries of royal decrees, administrative practice, and imperial expansion. The specific provisions on those tablets, the veil laws, the vicarious punishment clauses, the river ordeal procedures, were not the law being applied in Assyrian courts in the 7th century before the birth of Christ. Someone chose to preserve them anyway. What remains unexplained is what that choice meant. Two theories present themselves, and they lead in very different directions. The first theory, favored by scholars who emphasize the chaos of the city's final hours, is straightforward. Someone, a scribe, an administrator, a person with access to the archive and enough time to act before the Median army arrived, gathered the tablets and buried them in the hope of returning for them later. The tablets were valuable not because they were current law, but because they were ancient. They represented the accumulated legal wisdom of the empire's foundational period. They were the kind of document a civilization preserves because it understands that what is old is not necessarily what is obsolete. The second theory is quieter and more unsettling. It suggests that the tablets were already archival relics before the city fell, that they had been stored, catalogued, and maintained as historical documents for generations, possibly centuries, before the final crisis. And if that is true, it raises a question that the tablets themselves cannot answer. If the Assyrians of the late imperial period were preserving the Middle Assyrian laws as historical documents rather than active legal codes, what did they understand about those laws that we do not? Did the gap between the written code and the actual practice of their own time register to them as progress, as loss, as a record of something that had been, that was no longer, that nonetheless deserved to survive? Stefan Jakob of the University of Mainz, who has conducted ongoing reanalysis of the André excavation records and the Building G context, has noted in recent scholarship that the identification of the building's original function remains genuinely unresolved. The Deutsche Orient Gesellschaft reports from the original excavation describe it as a possible administrative archive or scribal school, but the physical evidence supports multiple interpretations, and the question has not been settled by subsequent analysis. The building that held the most detailed surviving record of how Assyria governed its people was a building that nobody can currently identify with certainty. That particular irony is one that scholars tend to note and then move past, because there is no scholarly methodology for sitting with irony. But it is worth pausing on for a moment. The laws that govern the most intimate details of millions of lives, what women wore, what happened to a debtor's children, how a man's body was marked for the crime of kissing the wrong person, survived because someone buried them in a building whose purpose we do not fully understand, in a city being destroyed by an army that would leave no survivors capable of explaining the choice. They waited beneath the ground for nearly 3,000 years, undisturbed, patient in the way that only objects without consciousness can be patient. And when Walter André's team finally lifted them into the light of the early 20th century, the first thing the tablets did was begin, slowly and with considerable scholarly effort, to speak. What they said has been making people uncomfortable ever since. There are 14 groups of tablets in the Middle Assyrian Laws. Scholars label them alphabetically, Tablet A through Tablet O, a clean, orderly system that implies a completeness the actual physical record does not support. Tablet A survives in relatively good condition, which is why it dominates discussions of the code. Its 59 provisions about women, bodies, and civic conduct can be read, analyzed, debated, and translated with reasonable confidence. A handful of other tablets survive with enough intact text to yield coherent legal provisions. The rest are fragments, gaps, and silence. Tablet groups D, E, F, H, I, J, and K either survive only in pieces too damaged to yield coherent legal provisions or are missing entirely from the recoverable record. What those tablets covered, which categories of human conduct they governed, which penalties they specified, which classes of people they addressed is information that does not currently exist in any archive, museum collection, or scholarly database anywhere in the world. It is simply gone, or it is buried somewhere that has not yet been excavated, which is a different kind of gone, but functionally identical from the perspective of the present moment. The question of what the missing tablets contained is one that Assyriology has circled for over a century without being able to answer directly. What scholars can do, and what several have done with considerable methodological care, is reason from the pattern of what survives toward a theory of what does not. The surviving tablets deal heavily with women, slaves, property, and debt. They address the bodies and conduct of the people at the lower and middle registers of Assyrian society with extraordinary thoroughness. What they do not address, in any surviving provision, is the conduct of the people at the top. There is no surviving law in the Middle Assyrian Code that governs the king. There is no surviving provision specifying what happens when a royal official abuses his administrative authority. There is no surviving clause limiting what a judge may take from a defendant beyond the written penalty, only the inverse, the clause granting permission to exceed it. There is no surviving provision addressing what a military commander may do to civilians in conquered territory, or what legal protections, if any, applied to the populations absorbed into the empire through conquest. The people who are most thoroughly governed in the surviving tablets are women, slaves, and debtors. The people who are most conspicuously absent from the surviving tablets are the king, the nobility, the military command, and the priestly hierarchy. One theory suggests this absence is exactly what it appears to be, that the missing tablets covered military law, royal conduct, priestly accountability, and interstate treaty obligations, and that the physical loss of those tablets is the reason we cannot read them today. Under this theory, the Assyrian legal system was more comprehensive than the surviving record suggests, and the impression of a law that governed the powerless, while exempting the powerful, is an artifact of incomplete preservation rather than a reflection of how the code actually functioned. Another theory takes the absence at face value. It suggests that no such provisions ever existed in written form, that the governance of the king and the nobility operated through a separate, unwritten tradition of customary practice and royal prerogative that was never codified on clay, precisely because codification would have created a standard against which royal conduct could be measured and found wanting. The king who writes down the limits of his own authority is the king who has created a document that can be used against him. Eckhart Fromm of Yale University, in his 2023 book on the history of Assyria, published by Basic Books, notes that the complete absence of any provision governing the king's personal conduct is one of the most significant structural features of Mesopotamian law codes generally, not just the Assyrian ones. Hammurabi's famous code, for all its elaborate framing of the king as shepherd and protector, also contains no provision specifying what Hammurabi himself must do or refrain from doing. The law codes of the ancient Near East are, without exception, codes that govern the governed. The governors are present only as the source of the law, never as its subjects. What remains unexplained is whether this was a conscious political choice or a structural assumption so deeply embedded in Assyrian political theology that it never required articulation. If the king is the deputy of the god, and the god is the source of all law, then the king is not under the law he is, in a meaningful theological sense, the law's origin point. Writing a provision that constrained the king would be, within that framework, a category error. You do not write a law governing the sun. The missing tablets raise a second question that is more difficult to frame but equally persistent. The surviving tablets were found in Building G at Ashur, a single location, a single deposit, a single moment of concealment or preservation. But Assyria was an empire that administered territory stretching across the entire ancient Near East, with provincial capitals, military garrisons, trading colonies, and administrative centers distributed across what is now Iraq, Syria, Turkey, and Iran. The legal tablets found at Ashur represent one archive from one city. The legal documents that govern daily life in the provinces, in the military colonies, in the conquered territories, in the trading outposts, where Assyrian merchants operated under their own legal frameworks. Those documents have not been recovered in comparable form. Archaeologists have noted that the Kültepe tablets in Turkey, the archive of the old Assyrian trading colony at Kanesh, contain legal provisions and dispute resolutions that do not appear in the Mal tablets at all, suggesting that the law operating at the edges of the Assyrian world was not identical to the law operating at its center. The empire may have had multiple parallel legal traditions functioning simultaneously, adapted to local conditions, incorporating local custom, evolving independently of the canonical tablets stored in the capital's archives. How many of those provincial legal traditions existed, how extensively they diverged from the core code, and what provisions they contained that the central tablets do not. All of that is information that has not survived in recoverable form. What we have is the center. What governed the periphery, the margins, the people farthest from the capital, and most vulnerable to administrative discretion unchecked by any nearby authority. That record is among the most thoroughly lost portions of the entire Assyrian archive. One theory, suggested by several scholars working on provincial Assyrian administration, proposes that the absence of provincial legal rec is not accidental, that the further from the capital a population lived, the less interest the central administration had in creating durable written records of how they were governed. Because durable written records create accountability, and accountability was not the goal. The goal was compliance. Compliance does not require documentation. It requires enforcement. And enforcement, in a civilization that had written into its foundational legal code the authority to exceed any written penalty as many times as the judge pleased, needed very little additional paperwork. The missing tablets may tell us nothing because they never existed, or they may be buried somewhere beneath the plains of northern Iraq, in a sealed context beneath a floor in a building nobody has excavated yet, waiting with the same patience that the Building G tablets demonstrated for nearly 3,000 years. The ground there is deep and largely undisturbed. What it contains, nobody currently knows. The black obelisk of Shalmaneser III stands roughly 2 meters tall. It is carved from black basalt, a dense volcanic stone, and its 4 sides are covered with 5 registers of bas-relief images depicting foreign kings and their representatives bringing tribute to the Assyrian court. Above and below each register, cuneiform inscriptions describe the military campaigns and administrative achievements of Shalmaneser III, who ruled the Neo-Assyrian Empire from 858 to 824 years before the birth of Christ. The obelisk was discovered in 1845 by Austin Henry Layard at the site of ancient Kalhu, modern Nimrud, and it has been on display at the British Museum ever since, where it remains one of the most visited objects in the ancient Near Eastern collection. The second register from the top depicts a figure bowing so low that his hands touch the ground before the feet of the Assyrian king. The cuneiform inscription identifies this figure as Eowa, king of the land of Omri, a reference that most scholars identify as Jehu, king of Israel, paying tribute to Shalmaneser following an Assyrian military campaign into the Levant around 841 years before the birth of Christ. It is, incidentally, the only surviving contemporary image of a figure mentioned in the Hebrew Bible, which has made it one of the most analysed objects in all of ancient Near Eastern archaeology. But here is what the obelisk does not show. Administrative texts from the same period, cuneiform documents recording the actual governance of territories in the Levant that Shalmaneser claimed to have conquered and subjugated, show local rulers continuing to issue their own decrees, manage their own affairs, and conduct their own diplomacy with minimal interference from the Assyrian court. The kings depicted in postures of absolute submission on the obelisk were, in the documentary record of their own administrations, functioning with a degree of autonomy that the monument's imagery flatly contradicts. This is the central problem of reading Assyrian royal evidence. The monumental record and the administrative record describe different realities, and the question of which one reflects what actually happened is one that Assyriologists have been arguing about for a very long time. The Annals of Ashurnasirpal II, which appeared in an earlier section of this documentary in the context of the Infinite Punishment Clause, present the same problem at a more visceral level. The annals describe systematic atrocities, impalement, flaying, burning, towers of severed heads, in language so specific and so administratively calm that readers tend to assume one of two things. Either the events happened exactly as described, which makes the Assyrian imperial project one of the most deliberately brutal administrative systems in recorded history, or the events are rhetorical amplification, propaganda composed by royal scribes to project an image of terrifying power that exceeded the actual practice, which makes the annals a sophisticated instrument of psychological deterrence rather than a straightforward historical record. One theory, developed and refined by several scholars over the past few decades, holds that the annals operated primarily as deterrents. The explicit and detailed description of atrocities committed against people who resisted Assyrian authority was intended to be read or heard or seen in monumental form by people who were considering resistance. The message was not merely that Assyria had punished rebellion, the message was that Assyria would do the same thing to you in the same way, with the same administrative efficiency, if you made the same choice. Under this theory, the violence in the annals was real but selected and amplified for maximum rhetorical effect, a curated exhibition of the empire's capacity for cruelty, not a comprehensive account of its daily practice. The counter-evidence to this theory arrived in 1952, when excavations at Nimrud, under the direction of Max Mallowan, uncovered a cache of administrative correspondence that would be published by H.W.F. Saggs beginning in 1955 in a series of articles in the journal Iraq. The Nimrud letters, as they came to be known, changed the interpretive landscape in ways that the deterrence theory alone cannot fully accommodate. These were not public documents. They were not composed for an audience of foreign kings or potential rebels. They were internal communications between provincial officials and the royal court, the bureaucratic paperwork of empire, written to get things done and filed away when they had served their purpose. They were never meant to be read by the people they described. And in their mundane, practical, entirely untheatrical language, they describe executions and collective punishments and the physical destruction of communities with the same emotional register that a modern administrator might use to describe a budget allocation. A governor writes to report that a certain number of men have been dealt with following a grain supply failure. A military commander notes that a village that provided assistance to fugitives has been processed. The verb choices are bureaucratic. The tone is one of routine task completion. There is no pride in the language, no theatrical flourish, no sense that the writer understands himself to be describing anything extraordinary. That tone is, in its own way, more disturbing than the annals. The annals can be read as performance. The Nimrud letters cannot. They are the sound of an administrative apparatus that had so thoroughly normalized the application of extreme physical violence as a governance tool that it no longer required special language to describe. What remains unexplained, and what several contemporary scholars, including Karen Radner of Ludwig Maximilian University in Munich, have noted in recent work, is the precise relationship between the written law of the MAL tablets and the administrative practice documented in the Nimrud letters. The tablets specify penalties. The letters describe outcomes. The gap between them, the question of how often the written provisions were formally invoked versus how often officials simply acted on the discretionary authority the law had granted them, without reference to any specific written clause, is a gap that the surviving record cannot fully close. Radner's analysis of the Neo-Assyrian administrative system suggests that the empire operated through a combination of formal legal procedure and informal discretionary violence that were understood by everyone involved as part of a single, continuous spectrum rather than as separate systems. The formal law gave officials their authority. The discretionary authority gave them their flexibility. And the flexibility was the point. A king who followed his own laws to the letter was a king constrained by text. A king who used the law as the foundation for a discretionary authority that extended far beyond any written provision was a king who was, in practical terms, ungovernable by the same document that governed everyone else. The Assyrian kings understood this distinction with considerable sophistication. The obelisk shows foreign rulers with their hands touching the ground. The administrative letters show those same rulers managing their own affairs with relative autonomy. Both things were simultaneously true because the Assyrian system did not require literal submission. It required the performance of submission, combined with the delivery of tribute, combined with the credible ongoing threat of what would happen if either stopped. The law was the foundation of that threat. Whether the king followed it was, in a system where the king was also the law's ultimate interpreter and enforcer, a question that could only be asked from outside, and the people inside had no mechanism for asking it. There is a woman whose name does not appear in any tablet. She knew which plants reduced fever and which ones stopped bleeding. She knew how to turn a baby that was positioned incorrectly before birth and how to manage the hours afterward when the bleeding would not stop. She knew the words that were spoken over the sick, the objects placed at doorways to deflect harm, the small clay figurines pressed into the walls of houses where a family had suffered too much loss in too short a time. She had learned these things from the woman before her, who had learned them from the woman before her, in a chain of transmitted knowledge that stretched back further than any written record. She did not call herself a witch. Her neighbors may have called her something else entirely, depending on whether what she did had recently worked or recently failed. In Assyrian civilization, the boundary between medicine and magic was not a boundary, in the way modern people understand boundaries, a clear line with a labeled side on each end. It was a gradient, a continuous spectrum along which healing practice, religious ritual, protective magic, and what we would now recognize as pharmacological knowledge all occupied adjacent and overlapping territory. The woman who delivered babies, and the woman who performed protective rituals, and the woman who prepared herbal remedies were often the same woman. Her knowledge was comprehensive precisely because the domains were not separated. The Middle Assyrian Laws did not see it that way. Tablet A, Provision 7, covers the case of a man who tells another man's wife in private, away from witnesses, that he has heard she practices witchcraft. Provision 17 covers a woman formally accused of sorcery before the community. Provision 47 extends the legal framework around sorcery accusations into the household, addressing the scenario of a husband who discovers objects in his home that he believes to be magical implements. In every case, the accused is understood to be a woman. The language of the provisions does not exclude male practitioners of sorcery in a grammatical sense, but the consistent framing, the default subject of these particular laws, is female. The Maklu ritual texts a body of Neo-Assyrian anti-witchcraft incantations running to 9 tablets and over 100 individual spells, analyzed in extensive detail by Tzvir Bush of Brandeis University in his 2002 study, published by Brill, similarly construct the figure of the witch as overwhelmingly, almost exclusively female. The witch in Assyrian religious and legal imagination is a woman who has inverted her relationship with the divine hierarchy, who has taken the knowledge she possesses and turned it against the community that should have been its beneficiary. The gender specificity of this construction is not incidental. It maps directly onto the social position of the women who held traditional healing and divinatory knowledge in Assyrian communities, women whose authority derived from a body of transmitted practice that existed outside and independent of the male-dominated institutional structures of temple and palace. Their knowledge was not sanctioned by the state. It was not administered by the priests of Ashur. It did not flow downward from the king as the deputy of the god. It came from somewhere else, entirely from women, from households, from the accumulated experience of bodies managing the crises that official medicine and official religion did not always reach in time. One theory suggests that the sorcery laws functioned as a legal instrument for suppressing precisely this category of independent female authority, that the formal accusation of witchcraft was a mechanism by which women who held knowledge and social influence outside the sanctioned institutional channels could be neutralized, their authority dissolved, their networks disrupted through a legal process that required no direct evidence and could be initiated by anyone willing to make a formal claim. This theory cannot be proven from the legal texts alone, because the legal texts record provisions, not motivations. What it can draw on is a body of archaeological evidence that is, in several respects, suggestive. Augusta McMahon of the University of Cambridge, whose work on Assyrian domestic archaeology has contributed significantly to the understanding of household religious practice in the ancient Near East, has surveyed the distribution of female figurines across Assyrian sites spanning multiple centuries. These figurines, small clay objects depicting women, found in domestic contexts across the region, associated in the scholarly literature with apotropaic practice, meaning the use of symbolic objects to deflect harm and protect households, show a pattern in their archaeological distribution that has attracted considerable attention. The figurines are present in domestic contexts across Assyrian sites in the earlier periods. In the Middle Assyrian peak period, roughly 1200 to 1100 years before the birth of Christ, the same period in which the MAL tablets were inscribed and the sorcery provisions were in active use, their presence in the archaeological record diminishes sharply. By the late Middle Assyrian period, the category of female protective figurines in domestic Assyrian contexts has contracted significantly compared to what came before, and, interestingly, compared to what appears in contemporary non-Assyrian sites in the same region. What remains unexplained is whether this contraction represents a genuine cultural suppression, the legal and social pressure of the sorcery laws, forcing the practice of household protective magic underground or out of existence, or whether it reflects a shift in how objects were used, stored, or discarded that leaves a different kind of archaeological signature, rather than an actual absence of practice. McMahon's analysis acknowledges both possibilities and does not claim to resolve the question definitively, but the coincidence of timing is difficult to set aside entirely. The harshest written provisions governing sorcery accusations appear in the same period and the same civilization, in which the archaeological evidence for the kind of domestic female ritual practice most likely to attract those accusations begins to fade from the visible record. The Maklu texts add another layer to this picture. These incantations were not popular folk literature. They were palace documents. They were composed, maintained, and performed by officially sanctioned exorcist priests, the Arshipu, who operated within the institutional structure of the Neo-Assyrian court. The rituals they describe are elaborate, requiring specific materials, specific timing, specific sequences of action. They are professional procedures, not improvised responses, and what they describe is a civilization so institutionally preoccupied with the threat of female sorcery that it maintained a formal professional class whose primary function was countering it. The official response to witchcraft was itself a form of magic, administered by men, sanctioned by the state, directed overwhelmingly against women. The woman whose name does not appear in any tablet may have understood, toward the end, what the legal machinery around her was actually for. Not to protect the community from supernatural harm, not to adjudicate genuine cases of malicious sorcery with the kind of evidentiary care the Assyrian system applied to commercial disputes, but to make certain that the knowledge she carried, and the authority that knowledge conferred, did not survive the generation that held it. Whether it succeeded is one of the questions the archaeological record has not yet finished answering. The stele of Hammurabi is one of the most recognizable objects in the ancient world. It stands 2.25 meters tall, carved from a single piece of black diorite, and its upper register depicts a scene that has been reproduced in textbooks, documentaries, and museum guides for over a century. The king Hammurabi of Babylon, who ruled from roughly 1792 to 1750 years before the birth of Christ, stands before the seated figure of Shamash, the sun god and god of justice. The god is handing something to the king, or the king is receiving something from the god. The exact nature of the transaction has been interpreted differently by different scholars, but the image communicates its central message without requiring interpretation. The king receives the law from the divine. The law is therefore sacred. The king who administers it is therefore the servant of justice rather than its origin. Below that image, covering the remaining surface of the stele in dense cuneiform columns, are 282 provisions, governing the conduct of life in Babylonian society. Property disputes, wage regulations, responsibilities of builders whose structures collapse, treatment of slaves, adoption, marriage, the duties of tavern keepers, the penalties for surgeons whose patients die. The range is comprehensive, and the organization is, by the standards of the ancient world, remarkably systematic. At the top, a prologue. At the bottom, an epilogue. The prologue announces Hammurabi's divine mandate and his commitment to justice. The epilogue promises blessings to future kings who uphold the code and curses on those who deface or ignore it. The whole structure, divine authorization, legal content, moral framework, forward-looking legacy reads, to a modern eye trained on Western legal and religious traditions, like something almost familiar. That familiarity is not accidental, and it is a large part of the explanation for what happened next. The stele was discovered in December of 1901 and January of 1902 by a French archaeological expedition led by Jacques de Morgan at the site of ancient Susa in what is now southwestern Iran. It was not in Susa originally. It had been carried there as war loot by the Elamite king Shutruk-Nahunte, who sacked Babylon around 1155 years before the birth of Christ and took the stele as a trophy, along with a number of other monumental objects. A section of the legal text estimated at several columns of provisions was partially erased, possibly to make room for an inscription commemorating the Elamite conquest that was never actually added. The blank space on the stele today is where those provisions used to be. The object that the world has come to regard as the foundational monument of legal civilization is, in its physical form, a piece of looted property with a blank space where part of the law used to be. De Morgan shipped it to Paris, where it arrived at the Louvre in 1902 and has remained ever since in the Richelieu wing, inside a glass case in a room designed specifically to display it. Within months of its arrival, the cuneiform scholar Jean-Vincent Scheil had produced a complete French translation. Within a year, the stele was generating international coverage, academic excitement, and comparisons to the biblical legal tradition that would shape the way the Western world thought about it for the next century. The comparisons to the Bible were not incidental. They were, for many of the European scholars who first worked on the text, the primary frame of reference. The discovery of a law code from the ancient Near East, organized around a divine mandate, with provisions that had clear structural parallels to sections of Exodus and Deuteronomy, arrived in a scholarly world that had been deeply invested for decades in using ancient Near Eastern archaeology to illuminate, confirm, or contest the historical claims of the Old Testament. Hammurabi's code fit that framework with remarkable convenience. It could be positioned as a precursor to biblical law, an ancestor of the legal tradition that European civilization understood as its own foundation. The Middle Assyrian Laws could not be positioned that way. They were translated and published in the same decade. Otto Schroeder published the first complete edition in 1920, followed by the scholarly analysis of G.R. Driver and John Miles in their 1935 Oxford volume. The academic community that received the MAL was the same community that had celebrated Hammurabi's code, but the reception was notably different. Hammurabi's code had a prologue about protecting the weak. The Middle Assyrian Laws had no prologue at all. They began with provisions about women being punished for what men did to them. Hammurabi's code had an image of divine authorization that fit neatly into the iconographic tradition of law as sacred gift. The Middle Assyrian Laws had the infinite punishment clause. Hammurabi's code could be positioned, with some rhetorical effort, as a distant ancestor of the tradition that produced Magna Carta and Roman law and the legal structures of Western modernity. The Middle Assyrian Laws resisted that positioning with every provision. One theory, developed with considerable nuance by Mark van der Meeroop of Columbia University in his 2005 study of Hammurabi published by Blackwell, suggests that the elevation of Hammurabi's code to iconic status in Western historical consciousness was shaped less by its actual legal significance than by its structural resemblance to legal and religious forms that 19th and early 20th century European scholars already valued. The stele looked like something they recognized. It confirmed a narrative about the deep roots of Western civilization that the scholarly culture of the period was actively interested in confirming. The Middle Assyrian Laws disrupted that narrative. They suggested that the ancient Near East had also produced something systematically more brutal, more comprehensive in its control of women and slaves and debtors, more explicit in its authorization of judicial excess, and that this too was part of the legal heritage of the region that had given the world the Bible and, by the reasoning of the period, the foundations of civilized law. There is a replica of Hammurabi's stele in the lobby of the United Nations headquarters in New York, donated by the government of Iraq in 1971. It stands there as a symbol of the ancient roots of international law and the universal aspiration toward justice. The Middle Assyrian Laws tablets are held in the Louvre Museum in Berlin, in the collection designated as the VA 8924 series. They are available for scholarly examination by appointment. They do not have a lobby. Archaeologists have noted that the disparity in public recognition between the two codes is itself a historical artifact, a product of the specific intellectual and cultural context in which both were discovered, translated, and introduced to a modern audience that was already looking for particular things, and found, in one case, exactly what it was looking for. What it was not looking for was a legal system that had written the systematic destruction of ordinary people into its foundational provisions with the calm confidence of a civilization that saw no contradiction between that destruction and its own understanding of justice. The contradiction was always there. It was simply easier, for a very long time, to look at the king receiving the law from the god and see the beginning of something, than to read what the law actually said and see something else entirely. When you encounter mutilation as a legal penalty for the first time, the instinct is to categorize it barbaric, primitive, the product of a civilization that had not yet developed the moral sophistication to understand punishment differently. It is a natural response, and it is also an analytical error because the moment you categorize something as barbaric, you stop asking why it was done, and the why is where the actual history lives. The mutilation penalties in the Middle Assyrian laws were not the residue of an undeveloped legal imagination. They were the expression of a highly developed one. They emerged from a specific theory of punishment that had internal consistency, institutional logic, and a coherent relationship to the economic and social realities of the civilization that produced them. Understanding that theory does not require approving of it, but it does require setting aside the reflexive categorization long enough to ask what the system was actually trying to accomplish. Start with the most fundamental question. Why mutilate rather than kill? The answer begins with labor. The Assyrian Empire at its height was an agrarian and military economy that depended on human bodies in very direct and very large-scale ways. Bodies built irrigation systems. Bodies harvested grain. Bodies constructed city walls, temple complexes, palace foundations. Bodies marched in armies that required not just soldiers, but an enormous logistical tail of support personnel, carriers, craftsmen, administrators, food producers. The demand for human labor in an empire of this scale and ambition was, by modern standards, almost incomprehensible in its scope. An executed person contributes nothing. A mutilated person can still work. This is not a cynical reading imposed from outside the system. It is a principle that appears to have been understood and applied with considerable consistency within it. The mutilation taxonomy in the Middle Assyrian laws is not random. It is calibrated. Different offenses produce different mutilations. And the calibration follows a logic in which the goal is maximum punishment with minimum loss of productive capacity. Consider the nose. Removal of the nose is specified in the Middle Assyrian laws for harboring a runaway slave, for certain categories of adultery, and for several other offenses that involve a violation of social boundaries and civic obligations. The nose, in the context of ancient Near Eastern physiognomy and social practice, was one of the most socially visible features of the face. Its absence was immediately apparent, impossible to conceal, and permanently legible as a mark of legal condemnation. A person without a nose could not pass through a marketplace, enter a public building, or conduct a commercial transaction without every person present understanding instantly that they had been convicted of a serious crime. The nose removal was therefore simultaneously a punishment, a mark of permanent social stigma, and a surveillance mechanism. It branded the convicted person for life without removing them from the economic system. They could still plant, harvest, carry, build, and produce. They were permanently identifiable as someone the community should regard with legal suspicion. And they were alive to experience the social consequences of that identification every day for the rest of their lives. One theory suggests that in an empire chronically short of labour due to continuous military campaigns that removed working-age men from the agricultural workforce for extended periods, the preference for mutilation over execution in a significant number of cases reflects a rational calculation about human resource management. Killing your labour supply to punish it is economically self-defeating. Marking it and returning it to work is not. The ears were frequently paired with the nose, both removed together, for offences involving concealment, deception, and the harbouring of fugitives. The pairing amplified the visible marking without adding significantly to the physical incapacitation. A person without both nose and ears is unmistakable. There is no ordinary social context in which their presence does not communicate their legal history to every observer. The lips appear in a provision that is, on its face, one of the more surprising specifications in the entire code. Middle Assyrian Law, Tablet A, Provision 9, addresses the act of kissing another man's wife without her consent in a public space. The penalty is 50 strokes of a rod and 1 month of compelled labour, or, at the accuser's discretion, cutting off both lips. The lip removal provision exemplifies the mirror logic most clearly in a non-violent context. The lips committed the offence. The lips answer for it. The instrument of the crime becomes the site of the punishment, and the person who emerges from that punishment carries, on their face, a permanent record of exactly what they did. The finger provisions cluster around the assault laws and follow the same proportional mirror logic. A finger for a strike. A specific finger or combination of fingers corresponding to the specific injury inflicted. The gradation is precise in ways that suggest the code was designed by people who thought carefully about how punishment could be proportioned to harm without defaulting to the simpler calculus of death. The eyes are reserved for the most severe non-capital offences, situations where the law determined that permanent incapacitation was warranted, but death was not the appropriate outcome. Blinding in the Assyrian legal context functioned as what might be called civil death, the removal of the person from full participation in civic and economic life, without removing them from life itself. A blind person, in ancient Assyria, could not farm independently, could not serve in a military capacity, could not navigate urban commerce with the same freedom as a sighted person. They became dependent on household support networks for survival. The punishment imposed a permanent reduction in status and autonomy that was, in practical terms, more comprehensive than many of the physical penalties lower on the scale. Castration appears in Tablet A, Provision 20, for a man convicted of sexual assault against another man. 50 strokes, 1 month of labour, and castration. The mirror logic here operates on a different register, not physical correspondence between offence and punishment, but symbolic correspondence between the capacity used to commit the crime and the capacity removed as consequence. The overall architecture of this system reveals something that is easy to miss when individual provisions are examined in isolation. The Assyrian mutilation penalties were not a menu of cruelties selected for their emotional impact on the condemned. They were a grid, a systematic matrix of punishments calibrated to offence severity, social visibility requirements, and labour preservation imperatives, operating within a legal philosophy that understood the body as simultaneously the instrument of crime, the site of punishment, and a productive resource that the civilization could not afford to waste indiscriminately. That the people subjected to this grid experienced it as cruelty is not in question, but the people who designed it experienced it as something else. They experienced it as engineering. And the most unsettling thing about the Middle Assyrian punishment architecture is not that it existed. It is that it worked, that the civilization which produced it functioned, administered territory, maintained trade networks, and sustained itself for centuries, while applying this system to millions of ordinary people who had no framework for understanding it as anything other than the natural order of things. The grid was the world, and the world, for a very long time, did not know it could be otherwise. There is a specific kind of trap that does not look like a trap when you first step into it. It looks like a solution. A harvest has failed. The grain stores are empty. Winter is coming, or the dry season is coming, or the flood came at the wrong time and took what the field had produced. And now there is a family, real people, with names, with children, with a house they built or inherited, looking at the gap between what they have and what they need to survive until the next growing season. And there is a man in the city, a merchant or a temple official or a wealthy landowner, who has silver and who is willing to provide it. The transaction is legal, organized, administered by a system that has been refining commercial law for centuries. The interest rate is 25% annually, sometimes 33%. That is not a modern payday lending rate inserted for rhetorical effect. Those are the documented interest rates from cuneiform commercial tablets recovered from the old Assyrian trading colony at Kanesh, modern Kültepe in Turkey, dating to roughly 1900 years before the birth of Christ, and from later Assyrian and Babylonian commercial archives spanning several centuries. The rates are consistent across the record. 25% on silver loans, sometimes higher on grain loans, where the lender absorbed the risk of price fluctuation. The numbers are in the tablets, in the careful cuneiform script of professional scribes who recorded transactions with the precision of people who understood that the written record was the only thing standing between an agreement and a dispute. 25% annually on a debt you took out because your harvest failed means that after 1 year, you owe a quarter more than you borrowed. After 2 years, if you have not paid and the interest has compounded, you owe more than half again the original amount. After 4 years, you owe more than twice what you originally took, and you are still farming the same land, in the same climate, with the same tools, facing the same risk of another bad season that drove you to borrow in the first place. The mathematics of this situation did not require a sophisticated economic model to understand. The people living inside it understood it. The lenders understood it. The scribes who wrote the tablets understood it. The legal system that governed the transaction understood it, which is why Middle Assyrian Law, Tablet B, Provision 2 existed, because the situation it described was not exceptional. It was routine. When a debtor could not repay, the creditor had legal recourse to the debtor's household, not to the debtor's future earnings, structured as a repayment plan, not to the debtor's property, seized and liquidated to satisfy the debt. They were taken into the creditor's service and put to work, and they worked until the debt was satisfied, with no mechanism specified in the surviving law for how their labour was to be valued against the principal or the accumulated interest. That last point is worth dwelling on. The provision authorises the creditor to take the family members and work them. It does not specify a labour valuation rate. It does not establish a timeline for reassessment. It does not require the creditor to maintain a running account of how much of the debt the pledged labour has offset. The family members work. The debt either gets paid by some other means, perhaps the original debtor manages to generate a surplus from the depleted household, or it does not. And if it does not, the working continues. The one limiting clause that the creditor may not deliberately kill the pledged family members is the entire extent of the legal protection afforded to people who had committed no financial offence and were serving as collateral for someone else's inability to repay. Archaeologists have noted that private archive texts from Nuzi, the ancient city in northeastern Iraq, excavated between 1925 and 1931 under the direction of Edward Chiera, with support from Harvard University, contained transaction tablets recording family transfers of extraordinary comprehensiveness. Maynard Maidman, whose 2010 analysis of the Nuzi archive published by the Society of Biblical Literature remains the standard scholarly reference for these documents, describes tablets in which entire household units are transferred as debt payment in a single transaction. The records are precise. Names appear. Ages sometimes appear. The tablet records the transfer with the same methodological care applied to the movement of grain or silver. The names are the most difficult part of reading these documents. They transform the transaction from an abstract legal provision into a specific human event. A woman named something, children named something, transferred on a specific day in a specific city to satisfy a specific debt, their labour, their bodies, their daily experience from that point forward, all of it redirected by a clay tablet the size of a human hand. What remains unexplained is the absence, in the Assyrian record, of anything equivalent to the periodic debt release edicts known from Babylonian practice. Several Babylonian kings issued what were called Misharim edicts, royal proclamations that cancelled certain categories of debt and freed debt pledges, typically at the beginning of a new reign or during periods of economic stress. Hammurabi issued at least one such edict. Other old Babylonian kings issued them with some regularity. The practice appears to have been understood as a royal obligation, a mechanism for periodically resetting an economic system that would otherwise trap an increasing proportion of the population in permanent debt bondage. No equivalent edict has been recovered from the Assyrian record. Whether this means Assyrian kings never issued them, or issued them and the records have not survived, or understood the political economy of their empire differently from their Babylonian counterparts, in ways that made such resets unnecessary or undesirable. None of these questions can currently be answered from the available evidence. One theory suggests the absence reflects a genuine structural difference between Babylonian and Assyrian approaches to economic governance, that the Assyrian state, built around a military expansion model that required continuous extraction of surplus from subject populations, had less institutional interest in the kind of periodic debt relief that might have reduced the available pool of dependent labour. The trap, under that model, the trap was the system, and for the families whose names appear in the newsy transfer tablets, moved from their own households into someone else's service by a debt they did not incur, under a law that protected the creditor's investment, while offering them the single assurance that they would not be deliberately killed. The distinction between a flaw and a feature was one they had no framework for making. They were inside the trap. The trap worked exactly as designed. In the summer of 612 years before the birth of Christ, the city of Nineveh burned. It did not fall slowly. It did not negotiate. It did not transition from one administrative regime to another through the kind of gradual political transformation that most large states experience when their power begins to wane. The capital of the largest empire the ancient world had yet produced was besieged by a coalition of Medes, Babylonians, and Scythians, and within months it was rubble. The palace complexes that Sennacherib and Ashurbanipal had built over generations, the structures that housed the greatest library in the ancient world, the rooms where the fate of Egypt and Babylon and Israel and a dozen other kingdoms had been decided by men sitting on carved stone thrones, were burned, looted, and buried under the collapse of their own walls. The fire baked the clay tablets. That is why we have them. It is one of the profound ironies of ancient Near Eastern archaeology that the destruction of Nineveh is, in a very direct physical sense, the reason we know as much as we do about the civilization it destroyed. Clay tablets survive fire. They survive it better, in many cases, than they survive simple exposure to air and water over centuries of peaceful abandonment. The library of Ashurbanipal, thousands of tablets covering literature, divination, medicine, history, and correspondence, collected by a king who understood himself to be preserving the accumulated knowledge of his civilization, was baked into permanence by the fires that killed the city around it. The tablets are now in the British Museum. The city they came from is a low mound on the outskirts of modern Mosul, in northern Iraq. What is historically remarkable about the fall of Nineveh is not the violence. Violent endings were not uncommon in the ancient Near East. What is remarkable is the totality and the speed. The Neo-Assyrian Empire at its height governed territory stretching from the Persian Gulf to the borders of Egypt. From the mountains of what is now Iran to the Mediterranean coast, it had a standing army, a professional administrative bureaucracy, a network of provincial governors bound to the center by loyalty oaths and regular tribute obligations, and a system of intelligence gathering and rapid military response that had defeated every significant rival it had faced for 2 centuries. Within a decade of the fall of Nineveh, it was gone, not diminished, not reorganized under new leadership. Gone. The provincial apparatus dissolved. The tribute networks collapsed. The administrative centers were abandoned or absorbed into successor states. The Assyrian royal line ended. The language of Assyrian administration, a form of Akkadian cuneiform that had served as the diplomatic lingua franca of the entire ancient Near East, was replaced in the correspondence of successor states within a generation. 200 years after the fall of Nineveh, the Greek soldier and writer Xenophon led a column of Greek mercenaries through the plains of northern Mesopotamia and past the ruins of a large city on the Tigris. He described the ruins. He noted their scale. He recorded the name the local population gave to the site. He did not know it had been Nineveh. He had no framework for recognizing the largest city of the most powerful empire of the preceding century, because the memory of it had, in 200 years, faded to the point where a well-educated Greek writing in the 4th century before the birth of Christ could walk past its ruins without identification. That particular detail, more than almost anything else in the historical record, communicates what the fall of Assyria actually meant. What caused it remains one of the genuinely contested questions in ancient Near Eastern scholarship. The military explanation is the most straightforward. The Medo-Babylonian coalition was simply more powerful than the Assyrian forces available to resist it, and the empire that had survived challenges for centuries finally met one it could not overcome. This explanation is not wrong, but it is incomplete, because it does not account for the speed of the internal collapse that preceded and accompanied the military defeat. Eckhart Fromm of Yale University, in his 2023 History of Assyria, points to evidence of significant provincial defection in the years immediately preceding the fall of Nineveh, subject territories withdrawing their tribute obligations and their military contributions before the final siege, suggesting that the empire's hold on its periphery had already weakened substantially before the coalition armies arrived at the capital walls. An empire that could count on provincial loyalty would have been able to field a defense far more robust than what the historical record suggests Assyria managed in its final years. Karen Radner of Ludwig Maximilian University in Munich has emphasized in her work on the Neo-Assyrian period that the empire's administrative system, for all its sophistication, was built around the personal authority of the king in ways that made it structurally vulnerable to succession crises and internal political fractures. When the center weakened, the periphery did not hold. What remains unexplained is the ecological dimension. Palynological records, meaning the analysis of ancient pollen deposits preserved in lake sediments from Lake Van in eastern Turkey, studied by a team including Ari Stalduin and Meyer, and published in the Journal of Archaeological Science in 2018, document a pattern of repeated severe droughts in the region during the late 7th century before the birth of Christ. The timing coincides with the period of Assyrian political fragmentation. An empire built on agricultural surplus extraction, facing repeated harvest failures across its core territories, would have experienced compounding pressures on the tribute system, the military recruitment pool, and the administrative capacity to maintain provincial compliance simultaneously. One theory suggests the collapse was not caused by any single factor, but by the simultaneous failure of multiple systems that had previously compensated for each other's weaknesses: military overextension, provincial defection, ecological stress, and succession instability converging within a compressed timeframe that gave the empire no opportunity to recover between crises. But the laws did not collapse with the empire. The legal concepts that had been inscribed on clay tablets in Ashur during the Middle Assyrian period: vicarious punishment, debt bondage, the veil as legal status marker. The judicial authority to exceed written penalties did not disappear when Nineveh burned. They persisted. They appeared in Neo-Babylonian legal and administrative texts, composed after 612 years before the birth of Christ. They appeared in modified form in Persian administrative practice under the Achaemenid Empire that succeeded Babylon. Structural echoes of them appear in early Roman law, in the legal traditions of the Hellenistic kingdoms that carved up Alexander's empire, in the medieval European debt bondage institutions that legal historians trace back through a long chain of transmission and transformation to ancient Near Eastern antecedents. One theory suggests that Assyrian legal scribes were absorbed into the Neo-Babylonian court following the fall of Nineveh that the administrative and scribal class that had maintained and applied the Assyrian legal tradition found employment in the successor state, carrying their professional knowledge with them and embedding it in the new empire's institutional foundations. Scribal knowledge was valuable regardless of which dynasty controlled the throne. The men who knew how to write, administer, and interpret law did not become unemployable when their employer's city burned. The empire died in a single summer. The ideas it had written into clay outlasted it by centuries. And some of those ideas, the legal subordination of the family to the creditor's claim, the use of status markers to enforce social hierarchy, the judicial discretion to exceed written penalties, the treatment of women's bodies as instruments of legal settlement between men, did not remain in the ancient past, where we prefer to locate them. They traveled forward through time in the bodies of legal traditions that absorbed them without always acknowledging where they came from. The fire that destroyed Nineveh preserved the tablets. The tablets preserved the law. And the law, in forms that would not always be recognized as Assyrian in origin, kept moving through the world long after the last person who spoke Assyrian as a living language had drawn their final breath. On the 18th of February, 2015, a group of men entered the Mosul Museum in northern Iraq. They carried sledgehammers. What happened in the next several minutes was filmed and distributed deliberately, not as evidence of a crime but as a statement of intent. The footage shows men methodically destroying objects that had survived for thousands of years. A large Assyrian lamassu, one of the human-headed winged bull statues that had stood at the gates of ancient palaces to protect against evil, carved from stone during the Neo-Assyrian period, was pushed from its base and shattered on the floor. Smaller objects were lifted from display cases and broken against the ground. The sound of stone striking stone, of ancient surfaces fracturing, of things becoming irreversibly, former things that sound, runs through the footage, with a quality that is difficult to describe accurately without using language that overstates it, so it is better simply to say that it is permanent in the memory of everyone who has heard it. 2 months later, in April of 2015, the same organization turned its attention to the archaeological site of Nineveh itself, located on the eastern bank of the Tigris River, within the boundaries of modern Mosul. Bulldozers were used on sections of the ancient city. Explosives were detonated inside the Mosque of the Prophet Yunus, the Mosque of Jonah, which had been built over a church that had itself been built over what local tradition identified as the tomb of the biblical prophet, situated within the archaeological boundaries of the ancient Assyrian capital. The detonation destroyed the mosque and damaged the archaeological layers beneath it, layers that had been accumulating and preserving for nearly 3,000 years. The Iraqi State Board of Antiquities and Heritage, working under conditions of extreme difficulty and ongoing danger, has estimated that across the period of ISIS territorial control in northern Iraq, from 2014 to 2017, somewhere in the range of 100,000 objects were looted, destroyed, or displaced from archaeological sites and museum collections across the region. That number is an estimate, necessarily imprecise, because a full accounting requires access to sites and records that were themselves damaged or destroyed during the same period. The actual figure may be higher. It cannot currently be lower. Among the confirmed losses from the Mosul Museum were Assyrian artifacts of irreplaceable historical significance objects that had been excavated, catalogued, and stored over decades of archaeological work, representing the accumulated material evidence of a civilization that had already lost most of its physical record to the ordinary erosion of 3 millennia. The lamassu that was destroyed in the filmed footage was not a reproduction. It was an original, carved during the Neo-Assyrian period, somewhere between 800 and 600 years before the birth of Christ, by hands that have been dust for longer than most human civilizations have existed. What is harder to quantify, and in some respects more significant for the study of Assyrian law and governance, is the loss of cuneiform tablet collections whose cataloguing had never been completed. The excavation of northern Iraqi sites had been ongoing, with interruptions, since the 19th century. Objects recovered from the ground do not become known to scholarship the moment they are lifted out of the earth. They require cleaning, photography, description, analysis, and publication. A process that for a complex site with thousands of objects can take decades. Tablets sitting in storage awaiting full cataloguing are, for the purposes of scholarship, tablets that exist but whose content is unknown. When those tablets are destroyed or looted before the cataloguing is complete, what is lost is not merely the object. What is lost is the information the object contained, which cannot be reconstructed from the object's absence. Jafar Jothri of the University of Al-Qadisiyah, who co-authored a survey of looting damage published in the journal Iraq in 2017, has noted in his analysis that the targeting of Assyrian heritage sites by ISIS was not random or opportunistic in all cases. The organization demonstrated specific knowledge of site locations, specific capacity for identifying high-value archaeological targets, and a specific ideological framework articulated in their own publications in which pre-Islamic cultural heritage represented a form of idolatry that religious obligation required them to destroy. One theory, which Guthrie and others have raised with appropriate scholarly caution, suggests that the targeting reflected an understanding, however distorted, of what Assyrian heritage represented in terms of cultural and legal authority. The Assyrian Empire predated Islam by more than a millennium. Its legal and administrative traditions had influenced, through chains of transmission that ran through Babylon and Persia and Greece and Rome, the legal cultures of the medieval Islamic world. Destroying the physical evidence of Assyrian civilization was an attempt to sever a connection between the present and a pre-Islamic past, whose authority over the region's legal and cultural imagination ISIS was specifically trying to eliminate. Whether this theory accurately describes the organization's strategic thinking or projects too much coherence onto what was, in many cases, opportunistic violence, is a question that scholars continue to debate. What is not debated is the outcome. What remains unexplained is the full extent of what was lost. UNESCO's emergency report on Mosul cultural heritage, published in 2017, identified specific categories of loss, but acknowledged explicitly that a comprehensive assessment was impossible under the conditions that existed during and immediately after the ISIS occupation. Sites that had been partially excavated before 2014, yielding evidence of tablet caches or archive deposits that archaeologists had documented but not fully excavated, may now be damaged beyond the point where the remaining material is recoverable. The sealed contexts that preserve tablets, the undisturbed floors, the deliberately buried deposits, the foundation layers that have not been touched since the city fell, are precisely the contexts most vulnerable to bulldozer damage, because bulldozers do not distinguish between the fill above and the archive below. The legal record of Assyria was already fragmentary before 2015. The missing tablets groups D, E, F, and the others whose content cannot be recovered were lost to the ordinary attrition of 3,000 years. What happened in Mosul and at the Nineveh site added a new layer of loss on top of that ancient one, this time documented in high-definition video, this time deliberate, this time recent enough that the people who did it are still alive. Somewhere beneath the plains of northern Iraq, in sites that have not been excavated and may not be safely accessible for years or decades, there are almost certainly more tablets, more provisions, more evidence of how the Assyrian legal system functioned in the areas and periods where the current record is silent. Whether those tablets will ever be recovered, and whether the sites that hold them will be intact when archaeology finally returns, are questions that have no current answers. The ground holds what it holds, and what it holds, it does not yield easily or on any schedule that human urgency can compel. There is a version of history that works like a clean break. One civilization ends, another begins. The laws of the old world are buried with the people who wrote them, and the laws of the new world are invented fresh, by new minds, in response to new conditions. Under this version of history, what happened in Assyria 3,000 years ago is a historical curiosity, interesting, documented, disturbing in its specifics, but essentially sealed off from the present by the simple fact of its distance in time. That version of history is not accurate. Legal ideas do not die when the civilizations that produced them collapse. They travel. They get absorbed into successor legal traditions, modified by new political contexts, stripped of their original theological framing and reattached to new justifications, translated from one legal language into another across generations of scribes and administrators and scholars who understood themselves to be working with inherited material rather than inventing from nothing. The chain of transmission from ancient Assyria to the present is not a straight line, it is a web, tangled and discontinuous in places, occasionally impossible to trace with scholarly confidence. But the structural patterns that appear in the Middle Assyrian Laws reappear, with enough consistency and enough specificity in legal systems separated from Assyria by centuries and continents to suggest that something is being carried forward. Begin with the veil. The Middle Assyrian veil provisions, which specified exactly which women were required to cover their faces in public and which were forbidden from doing so, enforced by physical penalty, administered as a mechanism of legal status differentiation rather than religious observance, represent the earliest documented example in the written record of a state using dress as a legally enforced category marker for women. The specific cultural content changes across the subsequent 3,000 years. The theological justifications shift. The penalties differ. but the underlying structure, the state deciding which women must cover themselves and which must not, and enforcing that decision with legal rather than merely social authority, has appeared with remarkable persistence across the legal histories of multiple civilizations. The contemporary debate around mandatory religious dress codes in various modern states, and around legislation prohibiting or requiring specific forms of covering in public spaces, is structurally identical to the question the Assyrian veil laws were answering. Not theologically identical, not culturally identical, but structurally, meaning the question of whether the state has the authority to define and enforce women's dress as a legal category. The argument has not changed in its fundamental terms since Tablet A was inscribed in 1100 and 76 years before the birth of Christ. That persistence does not mean modern dress code legislation is Assyrian law in disguise. It means the underlying political question, who controls the visible presentation of women in public space, and what legal instruments enforce that control, is one that states have been answering in remarkably similar ways across a very long span of human history. Move to vicarious punishment. The principle that the consequences of one person's legal offense can legitimately fall on people close to them who had no involvement in that offense has never fully left the legal traditions that inherited it from the ancient Near East. It appears in modified form in modern laws that hold parents criminally liable for certain offenses committed by their minor children. It appears in asset forfeiture statutes in the United States and other jurisdictions, where property owned by family members can be seized as part of a criminal proceeding against someone else in the household without requiring proof that the family members participated in or even knew about the underlying offense. It appears in immigration enforcement practices that separate families as a consequence of one member's legal status. None of these modern examples require Assyrian law as a direct source. They require only that the underlying political logic that the family unit is a legitimate target for legal consequences generated by individual members remained available as an option to legal systems that faced problems for which collective punishment seemed like an efficient solution. It always seems efficient. That is part of what makes it persistent. The infinite punishment clause, the Assyrian legal principle that written penalties represent a floor rather than a ceiling, and that judges retain the discretionary authority to exceed them without written limit, maps onto one of the most contentious ongoing debates in modern American criminal law. The argument about mandatory minimum sentences, about prosecutorial discretion in charging decisions that effectively predetermine sentences before any judicial consideration occurs, about the gap between written law and actual sentencing outcomes. These arguments are all, at their structural core, arguments about whether punishment should have a ceiling or a floor. The Assyrian system answered that question clearly. It chose the floor. The debate has never fully resolved in the other direction. The debt cycle, documented in the Nuzi tablets, a family borrowing against necessity at interest rates that compound faster than agricultural income can repay them, resulting in the transfer of family members into the creditor's service, has a structural parallel in the modern payday lending industry that does not require any direct historical connection to be significant. Studies of payday lending patterns in the United States, published by researchers, including those at the Consumer Financial Protection Bureau, document loan renewal rates and effective annual percentage rates that produce debt cycles with the same mathematical properties as the Assyrian debt provisions. A borrower who cannot repay the principal by the due date pays a fee to roll the loan over. The fee compounds. The cycle extends. The original sum grows faster than the borrower's income can reduce it. The specific legal instruments are different. The underlying economic trap is identical. Archaeologists have noted, and here the word archaeologists is being used loosely to include legal historians and comparative law scholars, that the persistence of these structural patterns across civilizations, separated by millennia of distance, suggests something important about the relationship between legal form and social power. The specific content of law changes as theology, technology, and political organization change. The structural patterns that determine who law protects and who it extracts from tend to change much more slowly. The Middle Assyrian laws protected the creditor, the property owner, the husband, and the king. They extracted from the debtor, the slave, the wife, and the accused. The specific provisions that accomplished this extraction were products of their specific historical moment. The divine kingship theology, the agrarian labor economy, the imperial expansion model, the cuneiform scribal tradition. But the direction of the extraction, who the law worked for and who it worked against, is a pattern that did not require Assyria specifically to persist. It required only that the people designing legal systems kept facing the same choices, and kept making the same ones. Let us go back to Tuesday, the same Tuesday we started with at the beginning of this documentary. The coffee, the phone, the neighbor's yard, the street crossed before the light changed, the small lie told at work, the socket wrench still sitting in the garage. We have spent a considerable amount of time inside the legal architecture of the Assyrian Empire since that Tuesday was introduced, and now it is time to answer the question that was implied but deliberately left open at the start. Could you survive it? Not survive in the dramatic sense, not whether you could escape the empire or lead a rebellion or find some clever legal loophole that the scribes had accidentally left open, but survive in the most ordinary sense. Could you live a recognizable version of a normal human life inside the legal framework of the Middle Assyrian period without eventually running into a provision that ended or fundamentally destroyed that life? The answer is no, not because the laws were uniquely evil in some way that makes them categorically different from all other legal systems that have ever existed, but because of 4 specific structural features that, taken together, make survival in any meaningful sense essentially impossible for anyone living the kind of life that most human beings actually live. The first is comprehensiveness. The Middle Assyrian laws reached into every dimension of daily existence. What a woman wore in public, what happened between neighbors when a dispute turned physical, what a creditor could do when a debt went unpaid, what a person owed the state when they witnessed a crime and failed to report it. The code did not leave large categories of ordinary human behavior ungoverned. It did not create spaces where ordinary life could proceed without legal consequence. The provisions were dense, interlocking, and designed to cover the specific situations that actually arose in the specific civilization that produced them. The Tuesday scenario illustrates this precisely. Cutting across a neighbor's cultivated land is trespass on protected agricultural property, flogging, and compelled labor. The small lie told at work, if it touched any commercial or civic obligation, and in a civilization where employment, relationships, tribute obligations, and commercial contracts were all legally regulated documents, it very likely did, is bearing false witness, which carries mutilation to the mouth in its written penalty. The socket wrench, depending on whose property it originated from and how the claim was characterized, is either a debt obligation or a theft, both of which carry penalties ranging from financial ruin to execution. The street crossed before the light, there were no traffic lights, but unauthorized passage through controlled spaces, disruption of civic order, failure to observe the hierarchical protocols that governed movement through Assyrian urban spaces. All of these were areas of legal regulation. You would not make it to Wednesday. The second structural feature is the absence of a floor on enforcement. Every legal system has cases that fall below the threshold of actual prosecution situations, where the written law technically applies, but where the practical reality of enforcement means no action is taken. Modern legal systems rely on this gap extensively. Most people who exceed the speed limit are not prosecuted. Most people who commit minor civil infractions are not pursued. The gap between what the law technically covers and what it actually enforces is, in modern systems, one of the primary mechanisms by which ordinary life remains livable. The Assyrian system had no guaranteed floor of this kind. The infinite punishment clause operated in both directions, not just upward from the written penalty, but downward into situations where enforcement was at the complete discretion of whoever held authority. A judge who decided that an example needed to be made could reach into any technically covered situation and apply the full written penalty plus whatever additional measure he judged appropriate. There was no procedural protection against selective enforcement. There was no principle of proportionality that bound the judge's discretion downward. The third feature is the complete absence of anything resembling a public defender. In Assyrian legal proceedings, the accused appeared before the judge without professional legal representation. This was not unusual for the ancient world. The institution of professional legal advocacy is a relatively recent development in the long history of law, but its absence, combined with the comprehensiveness of the code and the discretionary authority of the judges, meant that a person accused under the Middle Assyrian laws had no mechanism for challenging the characterization of the offense, no procedural tool for contesting evidence, and no professional advocate whose job was to identify the weaknesses in the prosecution's case. You face the judge alone. The fourth feature is the one that is most difficult to sit with, because it is the one that requires the most imaginative effort to fully internalize. There was no appeals process. A sentence handed down by a judge in an Assyrian court was not the beginning of a legal process that could be contested, reviewed, and potentially reversed at a higher level of the system. It was the end of the legal process. The body of the convicted person was the instrument on which the sentence was carried out. And once that instrument had been altered, the nose removed, the eyes destroyed, the flogging administered, there was no mechanism for acknowledging that a mistake had been made and addressing its consequences. Mistakes, under this system, were permanent. So the answer to the question, could any modern person survive Assyrian law, is no. But the no requires a specific explanation that goes beyond the simple observation that the punishments were severe. Severe punishments exist in other legal systems that people nevertheless survive. The unsurvivability of Assyrian law is a product of its comprehensiveness, its discretionary enforcement without a flaw, its absence of legal representation, and its finality. Those four features together create a legal environment in which any person living a recognizable human life generates enough technical violations, enough situations of potential accusation, enough exposure to the discretionary authority of judges who had every legal right to act on it, that the question is not whether the system would eventually reach you. The question is only when, and the answer, for most people, would have been measured not in years, but in the small, ordinary moments of a single, unremarkable Tuesday. The tablets survived. That is the first fact, and it is worth sitting with before anything else is said. Across nearly 3,000 years of war, occupation, flooding, looting, and the ordinary entropy that reduces most human-made things to dust, a collection of inscribed clay survived beneath the floor of a building in a city that the world forgot existed. Walter Andre's team lifted them out of the ground in the early years of the 20th century, and scholars spent decades learning to read them, and what they read was a complete and functioning legal system for one of the most powerful civilizations the ancient world produced. The tablets survived. The people who lived under them did not leave a comparable record. This asymmetry is the thing that stays with you longest after spending time with this material. The Assyrian legal system generated an enormous volume of documentation: contracts, administrative correspondence, royal annals, tribute records, temple accounts. The empire was, among other things, a prodigious producer of written records, and a significant portion of those records have survived in recoverable form. What has not survived, in any comparable density, is the interior experience of the people the law was applied to, the women whose legal status was defined by whether they were permitted to cover their faces in public, the families transferred as debt payment in transactions recorded on tablets the size of a human hand, the people who stood at the riverbank accused of sorcery, looking at the water that would determine their guilt or innocence by the simple fact of whether it killed them, the men and women whose bodies were marked by judicial sentences carried out without appeal, without representation, without any procedural mechanism for challenging the characterization of what they had done. They were there. The law touched them in the most direct and physical ways that law can touch a person. And their experience of that contact, what they thought, what they felt, whether they understood the system they were inside as justice or as something else for which they may not have had a word, is almost entirely absent from the record that survived. One theory suggests this silence is itself a product of the legal system. A civilization in which speaking against authority carried the penalty of mutilation to the mouth did not produce dissenting literature. A population in which the consequences of civic non-compliance were written into law with the precision and comprehensiveness of the Middle Assyrian Code did not, in the ordinary course of events, generate documents recording its objections. The silence is not evidence of acceptance. It is evidence of a system that was very effective at ensuring that whatever was felt privately never became visible publicly. What the silence of the tablets tells us is something that the provisions themselves, for all their specificity, cannot say directly. It tells us that the most complete record of how a civilization governed its people is always the record the civilization chose to keep. The laws that survive are the laws the powerful inscribed and stored and, in this case, buried for preservation. The experience of living under those laws belongs to the people who had no scribes, no archives, no buildings designated for the storage of their perspective. They were there. For 3,000 years of silence, they were there. And if there is a reason to spend time with this material, to read the provisions, to follow the scholarly debates, to sit with the discomfort of what the tablets actually say, it is not simply because the history is remarkable, though it is because the act of reading what was written and asking what was not written is one of the small ways that the silence can be acknowledged, even if it cannot be filled. The tablets survived. They are still speaking. What they cannot speak for is everyone who lived inside the world they described and left no stone, no clay, no inscription of their own, only the faded outline of a life that the law touched and the record forgot. That outline is still there, beneath the silence, if you know how to look for it.